Hello again, everyone. It is Rob Ryder, and today I want to start with my DD-214. Get it out there right in the open. I mean, I've shown it before. There's no secret. But I'm hoping that by the time you've watched this video, if you may know of any officers of the United States, be they in the military or civil or whatever, I would ask that you ask them to watch this video. And for those of you that are and have never watched any of my videos before, well, how you doing? I am Robert Allen Rytlewski, a.k.a. Rob Ryder. Except my DD-214 says I'm Rytlewski, Robert Allen. Well, I've pointed out numerous times that is that's a fictitious name. That's like an adulteration of your God-given character. And if you look closely, I mean, it says name, and then it has in parentheses last, first, middle. Well, you don't need to necessarily pay attention to that. That's not my name. No, my name is Robert Allen Rytlewski. Of course, I didn't know these things way back in the day, and God, I don't know where this is from. It's been a long time since I've been in the Army, like 1988. And for the record, Social Security number 374506794 is my property, no matter what name you believe it to be in. And I'll show you, before we're done, that even your Social Security account isn't in your proper name. My proper name is Robert Allen Rytlewski. My Social Security card, or not the card, but the stub that goes with the card, says that the owner of the account is Robert A, middle initial, Robert, middle initial A, Rytlewski. Well, Mom and Dad didn't give them that. They did that on their own, and it was to cloud the title to my property. And this is all goes into how they make you a bond servant from the beginning of your birth. And before we're done, I hope to have shown you some of that, but not all of those parts are important for this discussion. But what I'm going to show you now is. So, I was in the military for 10 years, right? I was in the federal government. So if you are now, well, excellent. Do your damn job. Because I can't find an officer in the United States yet that is enforcing the laws of the United States. You just run away from them. I'm going to show you, some of the things that's wrong with this system, and you're on the inside. You need to go fix it. So here's what's going on. Where do I want to go to from here? Well, I'll close that one down. So how about we start here? Okay, so I'll show you what this came from in just a second, but this is really the only page we're going to look at in here. It says, before entering the duties as a magistrate judge, the appointee is required to take a judicial oath or affirmation prescribed by 28 U.S.C. 453 and the constitutional oath of office prescribed by 5 U.S.C. 3331. The second part, to me, being the more important, it says that's the constitutional oath of office prescribed by 5 United States Code, subsection 3331. So this character needs to take those. And who are we speaking of? Well, we're talking about the selection, appointment, and reappointment of United States magistrate judges. So these jokers that sit in black robes and call themselves United States magistrate judges need to have taken 2 separate oaths. And those would be, so here's 5 U.S.C. 3331. This is the constitutional oath of office that's required by an individual except the president, elected or appointed to an office of honor or profit in the civil service or uniformed services, shall take the following oath. I, Robert Allen Rytlewski, do solemnly swear that I will support and defend the Constitution of the United States against all enemies. Period. You could stop there for me. But if you need more, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. This section does not affect other oaths required by law. So, as we just saw, that they want federal judges to take magistrate judges to take a judicial oath also. And that's this one here. So each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I state their name, do solemnly swear that I will administer justice without respect to persons, and do equal right to poor and to the rich, and that I will faithfully and impartially discharge and perform all duties incumbent upon me as whatever their office is under the Constitution and the laws of the United States, so help me God. Thank you. So that's 28 U.S.C. 453, which, is a codified law. It's, I believe, Title 28 is all positive law. And so this would be considered a law of the United States, as would this. This is a law of the United States. If you were not to do these and then pretend to be the people that are supposed to do these, well, you would be in violation of the laws of the United States. And this gets kind of important because in Article 6 of the Constitution, the second section, basically, the Constitution and the laws of the United States which shall be made pursuant thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. I don't care what they tell you at the state. Federal law is supreme, but when you go to the federal to point out, things going wrong, they want to say it's a state issue. It's crazy, right? The senators, representatives, before mentioned, all members of the several state legislatures, and all executive judicial officers, both in the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. So that, I don't know really what that means. That second section, under the United States, I don't know if that's the same as of the United States, or this is like inferior. This is what of the United States is over those that are under the United States. Nevertheless, all these officers have to take an oath, and at the end of the day, they're talking about this oath right here. So, that's all well and good, but what does it have to do with us? Well, this is kind of what it comes down to, is, hopefully this don't take too long to open. Give me just a second here. Always something. We can go right here. Now, if you are already an officer of the United States, I'm going to ask you to please pay attention real close. This is off the internet. U.S. Army, Civilian Human Resource Agency, Europe Region, living and working overseas, all in processing forms, appointment affidavit SF-61, which it says the purpose of the form. The affidavit attested to on this form provide the official appointment of an individual into the federal service. It will be used to administer the oath of office for federal employment. It must not be signed until after administration of the oath of office by either a commissioned officer of the United States, the Armed Forces, or Notary Public, or an official U.S. citizen and Civilian Personnel Advisory Center of the Civilian Personnel Advisory Center. Jeepers, Bob. Okay, why is that important? Well, because this is what the form looks like here. All right, so this is a SF-61 form, and it's called an appointments affidavit. Well, first thing we should remember is it said we're supposed to be taking an oath of office by the law. Now we're taking appointment affidavits, and, well, that ain't the same words. If it ain't the same, it ain't the same. It ain't the same for a reason. But this is what it looks like. And you come down to here, and, right, so here is where it starts. This is the beginning of the oath of office. Now, I can see that it has above, I, comma, blank, do solemnly swear or affirm that. But I can just as easily see, well, that's not in the part they're calling the oath of office. And so, the words that go to this is, I, A.B., do solemnly swear or affirm that I will support and defend the Constitution of the United States against all right. So it starts with, I, A.B., do solemnly swear. That is part of the oath of office, the constitutional oath of office that you have to take if you're going to be an officer of the federal government. But that isn't what this appointments affidavit, known as the Standard Form 61, is doing. This has bifurcated the oath of 5 U.S.C. 3331 and made it invalid. You're not taking the oath of the Constitution. It's got all the words. They're all there, right? But nevertheless, oath of office starts here and goes down. Here in, from here down. And the do solemnly swear part just doesn't happen to be in there. Now, if they were reading this to you and you're standing there and you're going to take the oath and then you're going to come afterwards, you're going to come down here and sign it as the appointee and do the rest, when they speak it and you're raising your hand, you're just going to hear the words. But if you look at the document, all right, this is the memorial to the event, and this has just invalidated your appointment. You're an unconstitutionally appointed officer. If you're in the federal government, have one of these things in your official personnel file. They need to be fixed. It could be done with a stroke of the pen. The president could just issue a proclamation. Hey, the printer made a mistake, right? All oaths of offices are here and now constitutional. Well, they'll figure them words out. They got plenty of attorneys to figure them words out. I'm just pointing out, hey, this is wrong, and if you're relying on this, you are not an officer of the United States. As far as I'm concerned, now that you know, if you don't fix it, well, you're committing treason. All right, playtime's over. So that's the gist of what's going on. So I came across this last week, and I decided to, because I was in the complaint mode, where I'm just submitting a lot of complaints all over the place. Any place I can think of, I said, I'm going to submit a complaint. Now, and I'm not going to just submit a complaint anywhere. I'm going to submit a complaint to the Administrative Office of the United States Courts. And here in a little bit, we'll get into why that would be the place, but I'll just give you the Reader's Digest version. Because if you were to be filing a complaint for a federal claim, they call it, SF-95, it's going to end up going to this man right here, to the director through the Office of General Counsel of the Administration Office of the United States Courts. And they're going to decide if your claim is valid. But in those cases, the government is the defendant. And I don't want the government to be the defendant. I want the government to be the prosecutor, and I'll just be the ex rel plaintiff. I'll be its narrator. Right? So I'm the relator for the government. And if the government is the plaintiff, well, then there's no fee to have the process done. And you still get your remedy. The government's going to get it for you. So now, the Attorney General isn't your opponent. He's your advocate. And that's how you would make them your advocate. And it's really just a Qui Tam process of a criminal complaint. And so in a little bit, we'll look at some stuff about Qui Tam, the history of it. I mean, it goes back to the 13th century, and it was the way for a private citizen to have access to the king's court. And if you go back to the video of Buckley that I did here a couple months ago, I'm showing this book. They said, hey, in this book here, it says we're supposed to be going to the king's court, in Old England, and yada, yada, yada. And, if you knew any of my history, you would know that I kind of started out in this 4 or 5 years ago, reading like Blackstone, commentaries of English law, having never read anything about the law before, so it was all new to me. And, a lot of these ideas are just carried forward because we are in a system of common law based on the laws of England. Blah, 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 blah. So what did I have to say? All that being said, so my idea is, okay, well, the United States of America is a plaintiff, and I'm the ex rel, Robert Allen Rytlewski, plaintiff. Versus officers of the United States unconstitutionally appointed using SF-61 appointment affidavits of the U.S. Office of Personnel Management, because they're the ones who made the form up, and NSA number. So we can all know what document we're talking about, because the government loves to put everything by a number. There you are. NSA 75400064344015 is only one thing, and that one thing is an appointment affidavit. Complaint and written disclosure of unconstitutional appointment of individuals to offices in the United States as a means to obstruct justice, which is why this is done. And that's why I pointed out in the video of Buckley, which is talking about Buckley versus Vallejo, a Supreme Court case, in which the Supreme Court said that the members of the Federal Election Commission had not been constitutionally appointed. Well, if they have not been constitutionally appointed, their only option then is to have been unconstitutionally appointed, because they're appointed to the office. And it's like, well, what would the unconstitutional part be? Beyond the fact that they are, right? How would that be? Ended up, well, it's this SF-61 form. That, what did the form do? It bifurcated the oath. I love that word, bifurcated. Right? Put a line right through it. Boom, right? Made 2 out of 1. Split it. Invalidating it as the oath you can take to fulfill the Constitution, the constitutional requirement to be constitutionally appointed. And that's Article 2, Section 2, Clause 2, the Appointment Clause. That's what Buckley was about. Well, back to the complaint, now that we know who's who and what we're talking about. So James C. Duff, he is the director, care of Office of General Counsel, Administrative Office, United States Courts, Suite 7-290, 1 Columbus Circle Northeast, that's just wonderful. I mean, 1 Columbus Circle, that's like ground zero. Washington, D.C. It's, right next to the U.S., no, what do they call it, man? What's the train station called? Union Station? I believe it's Union Station. Right. Mr. Director Duff, we have a man-made disaster of biblical proportions for which Lord Almighty now demands your testimony by works. Absolutely, brother. You got to do right. Standard Form 61 appointments affidavits hereinafter, SF-61, NSN number, authorized, mandated by U.S. Office of Personnel Management, is an instrument of fraud used to ensure appointed officers of the United States are unconstitutionally appointed and lawfully powerless to enforce the laws of the United States. Can you see how that would be? Right? And so instead of having officers you can bring a complaint to, all we have are a bunch of counter trolls that are basically obstructing justice. Any officer of the United States who depends on this official government record as evidencing his subscribing the oath required under Title V U.S. Code has instead been purposely appointed unconstitutionally. The style of SF-61 has bifurcated the oath of office mandated by law, rendering the resulting phrasing to not be as prescribed by Title V of the U.S. Code 3331. And there's only one thing about a procedure. Either you're following it or you're not. And if you're not following it as an NCO, which is what I am, you are incorrect. And, we're going to correct your fucking behavior. An individual, except the president, elected or appointed to an oath of honor or profit in the civil service or the uniformed services, shall take the following oath, which we already read. This is, Title V, U.S. Code 3331. I don't see any line through here that separated I, A, B, do solemnly swear or affirm that from the next word, I will support. But as we've seen, there it is. They did it on the form. So this section does not affect. Okay, we got that. A quick inspection of the SF-61 will provide foolproof evidence that the wording of Section A of said form entitled Oath of Office does not fulfill the law and is therefore unlawful. The SF-61 is an antitrust instrument of bad faith and must be immediately rescinded, repealed, recalled, redone now. Fix it. Fix the form. Mr. Director Duff, you depend on the SF-61 to evidence your complying with 28 U.S.C. Code 601, in which it says the administrative office of the United States Courts shall be maintained at the seat of government. Where's the seat of government? What was the address again? 1 Columbus Circle, Northeast. That's ground zero. It shall be supervised by a director and a deputy director appointed and subject to removal by Chief Justice of the United States. I have to get a hold of Justice Roberts after consulting with the Judicial Conference. Oh, okay. Well, I'm going to complain about you, Director, if you haven't taken care of this yet, because I gave this to him last week to the Judicial Conference. The director and the deputy director shall be deemed to be officers for the purpose of Title V of the United States Code. Well, the only way they can be officers is to be officers. They'd have to take the oath in Title V. And I don't know, I didn't put this in here, but the other thing about this dude is he also has a seal. Right? And that's the idea of you need to have an official seal put on paperwork for it to be an official record. And we only ever go and get notary publics to put a seal on something, and that is only for private records. And we want to make it a public matter, and so it needs to have a public seal on it, and that's what the frickin' court has. Or, you know, an officer of the United States has. And they don't want us to go to these people, right? So they really hide this stuff. The SF-61 is apparently used by all agencies of the federal government and would be part of an individual's official personnel file as an official record. In Chapter 11, selection by the court of the selection, appointments, and reappointment of United States judges authorized by the director, James C. Duff, Director Administrative Office of the United States Courts. It states, before entering the duty of as a magistrate judge, the appointee is required to take the oath, judicial oath of, or affirmation, as prescribed 28 U.S.C. 453, and the constitutional oath of office prescribed by 5 U.S.C. 3331. So you understand that none of these judges sitting in a federal court are a judge because they haven't complied with Section B. Now, I'm going to say that's for the magistrate judges, who really is the ones we start with in our court cases. Or if you were going, you would end up probably in front of a magistrate judge first. Okay, well, if he hasn't done these two things, then he's not a magistrate judge. And so if if you have a loved one in jail right now, we need to go point this out to somebody who can do something about it. And that's the thing that, I really can't tell you what to do with it. I'm just pointing it out myself, and I'm going to go try to find out what to do with it. Doesn't mean it isn't wrong. Just, the whole thing is they're not following the law, so who's the dude you're going to convince to do what the law says to do? Maybe it's General Dunford. Just have Marines jump through windows. Pull out people in black robes, put them all in the FEMA camps, and, hey, the rest of us have it. We'll figure the rest out after that. How about the U.S. magistrate judges under your authority? Do they also rely on the SF-61 as proof of constitutional appointment? Well, of course they do. It says that's the piece of paper that you use it for. How about Article 3 judges? If so, then pick up the phone and order the courts closed until further notice. This is a national emergency and a man-made disaster. It is my belief you need to have the President of the United States issue a proclamation reappointing officers of the United States constitutionally by the most expedient means. Mr. Director Duff, you have a duty and a moral obligation to end the satanic scheme for which the current version of the SF-61 form is an instrument of. Maxims of equity since time immemorial do not allow statutes to be used as instruments of fraud, and I reject any rule of law or other procedural impediment hindering the extinction of this demonic system. I extend you my sovereign's immunity while you drop a stone on it for Lord Emmanuel, Christ Jesus of Nazareth. I declare independent perjury, the foregoing to be true and correct. Executed, 21st of April 2016. Somebody put an email comment saying, why do I put all this religious stuff in my things? Well, because that's how I feel. I'm just telling the truth. You don't have to believe it. I wish you did. I pray you do someday, but, I'm going to use it, man. It's a weapon. It's a weapon. They don't have an answer. If we want to be, we can be the instrument of God that Satan doesn't have an answer for, because we've survived the frickin' machine. There's very few people that are going to ever hear this video, right? So we're not talking, most people are sheep. They're going to stay sheep. They can be sheep. It's just somebody else needs to be overseen as the shepherd instead of those that are there today that, right, want the blood of the lamb. Okay, I think I pretty much covered that. That's phase 1 of this video. Before I go on any further, though, I might ask, because it's in Robert Allen Rytlewski, and it's Tuesday, April 26, 2016. Can you donate? Will you? Please, 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 please. I should have put it much more times. Please. I could use the help. My PayPal account I use as my daughter's email address. That is the PayPal account. It's Ashley Rytlewski, ASHLEYRYTLEWSKI @gmail.com. Or you can always stick it in the mailbox. Robert Rytlewski. Yeah, that is my closer to real name. Allen in there. If it was Robert Allen Rytlewski, then you could say it was my proper name. 10955 14 Mile Road Northeast, Rockford, Michigan 49341. So if you could just stop the video for a second and write those down, maybe go through the whole gyration, put the thing on, and then we can continue. But I got to pay rent at the end of the month in 4 days, and I don't have the money. And I have a really good landlord that, he's been really generous to me in the past, because there have been many times I didn't have the money. I spend all my time doing this, working for the common good. And I'm working for food. I just need a few more biscuits. I'm not trying to get rich on this. Believe me, I don't want to have to do this anymore. I'm just looking for a remedy. So, where would we go next? We would have to go back into here. Okay. How about we look at, because I got 2 or 3 different things I want to show, but look at some attorney stuff, because if you're not ready to do what I was just talking about, that, with the trying to figure out what to do federally, because you're in a court case and you got to take care of something yourself, right? And that's what most people who watch these are. You're involved in something, and it's coming after you, and it has an attorney, and it gets putting paper in front of you and, acting like you have to pay attention to it. Well, this is the membership application for somebody that wants to become a member of the State Bar of Michigan. The State Bar of Michigan welcomes qualified applicants who are entering the practice of law in this state. All attorneys who practice law in Michigan are required to be members of the State Bar. So I don't know what the State Bar is, but it doesn't necessarily have to be this website called the State Bar of Michigan. It's just called the State Bar. And we have the Michigan branch, basically. Anyways, so that's what happens. Not reading the whole thing. They have to appear and present Board of Law Examiners certification, sent by mail at mass swearing-in ceremony or to one of the circuit courts of the state. For a complete list of swearing-in ceremonies, go to some website. Upon motion made in open court by licensed Michigan lawyer, the court will administer an oath of office and enter an order admitting you to the bar of the state. You got 2 things there that you need to go and have the attorney who's coming against you prove. You could go to the Board of Law Examiners, right? Not the Attorney Grievance Board, not anything else. The Board of Law Examiners, you'll have one, and say that you want to see the certificate that they sent by mail so this guy can become an attorney, or you want to see the order that admitted him to be an attorney, because the order's coming from court, right? This is in open court. Upon motion made in open court. So this is a court hearing in the matter of some guy's name, right? He's going to be made an officer of the court. Well, where is the order that did so? Forget the bar card. Forget what they're telling you standing there. Say, Judge, until I see the order that made this man a attorney licensed to practice law, I believe he's in contempt of court. Take judicial notice and see what they do. Now, as we're going to see, I'm going to say, well, let's go immediately, instead of waiting until court, let's go find the attorney for the judge, who would be called a law clerk, and tell him to take judicial notice, because that's what his job is. After being admitted to the bar by the court, you must complete the membership application to become a member of the State Bar of Michigan. This application must be accompanied by a true or certified copy of your order of admission and payment required dues noted in the instructions. Right? So, again, this isn't to become a member of this organization called the State Bar of Michigan. This is to become a member of the State Bar of Michigan. Not an entity called the State Bar of Michigan, but the entity called the State Bar, which has an affiliate in Michigan. That's the way I see it. All I'm saying is, hey, make them show you the order of admission. After the membership application, order of admission, and dues payments are received and processed, your bar license number, right, P number. Now, that doesn't mean that P number has anything to do with anything else we're talking about. It's in parentheses. Is assigned. Right? Your bar license number is assigned. Well, what is it? A barred card will be sent by mail within 10 to 15 days of assignment of your P number. Well, ask them for their bar card. But I'd rather ask them for the order. Right? I want to see the order of admission from a court under a court seal from the county court or the Supreme Court, right? That's used. They're all using a common seal that says this man, woman, is authorized to practice law within the state of Michigan. And that's really all I want to show you on this thing right here. But this doesn't have anything with them to go take a test to see if they're smart enough to be an attorney. All right, this is these are other things they have to do. Now, part of that is they have to have this character and fitness request done, and this comes through the state or the board of law review. Is that what it is? Or were these other people were? Yeah, I guess I wasn't quite done with this other one here. Right? Basically, the board of law examiners is the ones that say if they are or are not an attorney. Name. So now the membership application. Only your correct name may be used on an official register. Your business address, related information aren't required on the application. What name? Only your correct name. That's why I keep telling people, if they're using a middle initial, they're not using the name that they're authorized to practice law in. What do they mean by that? Right here. First name, middle, last. Right? So you could ask to see, this is something you should be able to FOIA. For those that just like to research, right? You could just FOIA this membership application and see what name is on it. Now we'll see if they give it to you. There you are. So court admission is required for applicant admitted by taking bar exam and for applicants who have been admitted based on years of active participation in another U.S. jurisdiction. Each applicant to whom a certificate of qualification has been issued by the Board of Law Examiners. So what kind of certificate do they get? A certificate of qualifications. Remember here it said Board of Law Examiners certification. Well, now we know what it's called. Now it is called the... Oh, man, I just can't keep all these spots together. Here we go. Each applicant to whom a certificate of qualification has been issued by the Board of Law Examiners is required to appear personally and present the certificate to one of the circuit courts of the state upon motion made in open court by an active member of the State Bar of Michigan and the administration of the oath of office, the court will enter an order admitting you to the bar of the state. Show me the order. An applicant admitted special certificate or as special legal counsel is not admitted in one of the circuit courts. So they wouldn't have an order that says that they're an active member. Right? This is an order from the court. Well, that's an official record. I want to see the damn record. All right, that's enough on that. Now, just real quick, this is so I believe this is the same for any state that, beyond going and taking a written test, they have to do this thing for a character examination, and these are all done through a central agency called the National Conference of Bar Examiners. And so they all have to fill out this report. And you can download this, you can download it online. It's easy enough to find. This is a sample, right? So just National Conference of Bar Examiners, request for preparation of a character report, and bingo, Google will have you looking at one in no time whatsoever. Applicant's name, first, middle, last. I don't see any initials there. Okay, and so we're going to start doing this, right? Away we go. They'd be filling this thing out as a roll, and then they get to like the first page of stuff, and it'd say list below all the other names or surnames you have used or have been known by, and describe when, how, and why your name was changed. They have an opportunity now to say they're using their middle initial name. If it isn't on this form and they're using the middle initial of their name, well, then they are not using the name that's on the license that is licensed to practice law that the order was written in. That would put them in contempt of court, because in the middle initial name, which is just a pseudonym, it isn't them, it's a fictitious name. That would be practicing law without a license. All right. See how easy that is? Cha-ching. You just ponder that for a little bit, you'll figure the rest out. I'm moving on. I got other things to do, but I do see where that would be very useful for somebody who has those problems. Again, just so we can go through it, you want to go look for the right. Just Google how to become an attorney in your state and start reading stuff, and eventually you're going to see that there's some kind of application they got to do. But if you wanted to look at one, this is the State Bar of Michigan membership application. Google it, look at it, go find your own. And this is, again, this is the questionnaire that everybody's going to fill out, and it's from the National Conference of Bar Examiners, request for preparation of a character report. Easy peasy. Okay, now, not ready for that yet. Don't need that one anymore. How did I want to go about this? Okay, let's look at, get all the information stuff out of the way, because when I was looking at the stuff for the attorneys, I came across just one little sentence of something that I said, oh, this is really, really interesting. It said that judicial clerks are considered to be engaged in the practice of law. Right? That a judicial clerk was engaged in the practice of law. And I thought about that for a second. I said, well, okay, first of all, who are they? Well, they're law clerks is who they're talking about. They work for the judge, and they're considered the judge's attorney. It's like, well, that dude's practicing law, and it's his job to put things together for the judge for a court case. So I should get, things that have to do with the law before a law clerk to have them make a legal determination for the judge of what he should do based on the evidence he's been provided. And so, hey, you would have them take judicial notice, right? I want them to take judicial notice of something. So let's do the judicial notices things first. So in the federal This is rules of evidence things, right? It says, all right, this is like the second set of rules. Judicial notice of adjudicative facts. This rule governs judicial notice of adjudicative facts only, not legislative facts. Well, they're just saying right there there's a distinction between the two. I'm not quite sure how you cover both bases except to say take judicial notice of the legislative and adjudicative facts. And then just start naming facts and hope that you hit something. Or study it out a little bit more. Or ask a law clerk and get some legal advice. Because they're working for the court, and technically the courts work for you. You're paying for them. I say that law clerk is my attorney. Kinds of facts that may be judicially noticed. The court may judicially notice a fact that is not subject to reasonable dispute because it's generally known, can be accurately or readily determined from sources. Taking notice, the court may take judicial notice on its own or must take judicial notice if a party requests it and the court is supplied with the necessary information. So if you tell the court to take judicial notice, it has to do so. Now, the thing is, who's the court? Right? The court isn't the clerk that we keep going to. I'm afraid that's the wrong clerk to give this to. The court hasn't seen it. The court will see it when it has a court seal on it. You'll know the court had seen it. And none of that shit you give that woman in that office over there has a court seal on it. They just have clerk stamps. The court hasn't seen it. Right? We need to get it before the court, which means it needs to have a court seal. That's simple. So ask who's got the court seal. And suggest, hey, where's the law clerk? They would know who has it. I need to talk to the judge's law clerk. He'll know who has the seal. I need to know how to get my paperwork to the judge under the court seal. Not just sealed from being seen. Sealed as having a court seal, which means it had been written into an official record that it's been entered into the court case. So just like a notary takes your paperwork and does her little thing in her book, that's for a private matter. This is a public matter. You're going to take it. They're going to put the official seal on it and write it in the official book. Well, right? Now justice can be served. So, must take judicial notice if a party requests it and the court is supplied with necessary information. Simple enough. What kind of things would you tell them? Well, I say, hey, the state gave a good idea on that. So that's federal. Now this is Michigan. So every state has their own rules of evidence, but they're numbered just like the federal, and they pretty much follow the federal, except they can add to them that they can't subtract. And it says rules governing this rule governs only judicial notice of adjudicated facts. Right? That reads just like the other one. Kinds of facts generally known within the territorial jurisdiction of the trial court, capable of accurate, ready determination by resort to sources. Easy. One discretionary court may take judicial notice, whether requested or not, and may require a party to supply necessary information. Opportunity to be heard. Time of taking notice, instructing. You can read all that yourself because I don't really care about the discretionary. I don't want to give them a choice. I'm going to make it freaking mandatory. But judicial notice of the law. So when discretionary, a court may take judicial notice without request by a party of 1. The common law, constitutions, public statutes in force in every state. That would be the laws of the United States. Territory and jurisdiction of the United States. Hey, just like it said. That's like Title 18, Title 28, Title 5, treaties, statutes at large. Pick one. They're all just different ways of saying the same thing, but they're all laws in the United States, and so they can be made to take judicial notice. And so once you do, well, now they got to pay attention to it. If you didn't tell them, then they don't have to pay attention to it. They could, but it's discretionary. But how do you make it conditionally mandatory? A court shall take judicial notice of each matter specified in paragraph A. What was in paragraph A? Well, the common law, the constitutions, the public statutes, private acts, resolutions of Congress, legislative of Michigan, ordinances, all sorts of things that have been written. Even the laws of foreign countries. I could bring them in some Vatican City law. I'll bring in some canon law. But I don't need to. I'm happy with the common law. Because common law, that would be the maxims of equity, and equity says you can't use a statute as an instrument of fraud. And so, there you are. Furnishes the court sufficient information to enable it to properly comply with the request, and has given each adverse party such notice as the court may require to enable the adverse party to prepare to meet the request. Well, that could be, but if I'm telling them to take judicial notice that this law has been broken and it's a crime, well, you can notice the adverse party by having them arrested. Judge? Okay. So let's read a little bit about what these law clerks do. Law school graduates accept a variety of clerkships with federal and state courts. Most clerkships involve working one-on-one with a judge. A clerk may be assigned to one judge or his or her entire clerkship, or may be part of a pool of clerks who rotate working one-on-one among a group of judges. A staff attorney is another type of clerkship. Staff attorneys work for an entire court. Well, that would be you. You're in court, they're working for you. Usually the federal appellate court. Staff attorneys generally have less individual contact with judges, and their functions include administrative duties such as reviewing appeals, correspondence, assisting in case management, handling settlement matters. The responsibilities, timing of applications, requirements vary circuit for circuit for these staff attorneys' positions. A pro se clerk is a specialized kind of staff attorney position. It handles pro se matters, which is typically include prisoner habeas corpus petitions, but it doesn't have to, but it could. And civil rights complaints. Well, yeah, I could have one of those. Employment discrimination complaints, Social Security disability appeals, right? Who does that? The person called a pro se clerk. Now they, as you'll see, every time you're going to see this now, someplace else, it's going to show it like, it's only for prisoners. Well, technically we are prisoners, because we've been charged with a crime, but no indictment has ever been handed down, but we've never gone to have the charge cleared for lack of prosecution. So in the record, hey, we've been charged with a crime and we're out on probation awaiting trial. There's never going to be a trial because, the grand jury never handed down an indictment. And that goes back to the Habeas Corpus Act 1863. Pro se clerk often screen cases, draft proposed orders of dismissal. They also assist pro se litigants by providing them with forms and information and guidance about the procedure. That's what I want. See, I want them to tell me how to do a Qui Tam procedure, upon which the United States of America is the plaintiff, and I'm merely the ex rel relator bringing it to the court's attention that laws in the United States have been violated, and the officers of the United States have a duty to enforce them. I'm not really trying to get it judged. I'm trying to get it executed. Most law clerk positions are term positions in that they are limited for a fixed period of time. They are also permanent or career clerk positions. Some federal trial court judges hire career clerks, and in some states, for example, California and New York, career clerk positions are more plentiful than term positions. So these would be some really, really, really smart attorneys. And they're working for the court, which means they're working for you, and they have an ethical duty. Now you can go look up their rules of professional conduct, what they're supposed to do. And one of them is to uphold justice. Right, so you need to show them that there's a violation of justice, and then they're going to have to tell the judge. And now the judge got some legal advice, and he can make a more sound decision. But until we tell them to take judicial notice, it's only conditional. It's not mandatory. They can if they want to. So, but if you tell them to, well, now they have to. Staff attorneys and law clerks provide the court with procedural and substantive legal advice regarding the disposition and efficient completion of cases. They review, summarize, research, analyze matters before the court. I'm not going to say anymore, right? They're supposed to be doing it. I didn't know this till a couple days ago, and I've already put a contact in trying to get a phone call. And that's how I like to plant seeds on paper, and eventually I might call them or I might get something in the mail. But on these particular ones, I'll be hammering these. So this is, that's what a law clerk is. They could be called a pro se law clerk. They could be called law clerk. They could be called a staff attorney. They could be called a judicial clerk. All different names, but what makes them different is they're not from the clerk's office. They're not from the clerk's office where we would normally think of that you're going to. This is somebody sitting in the back room. Now, I'm not saying you can't get a hold of them, and in fact, yesterday I found some addresses and so forth, and so you might find something like this. Clerk's office, you're in review. United States District Court, Western District of Michigan. Isn't that pretty, right? They're going to tell us what happened throughout the year, right? Court history, and it's probably really interesting, but I'm not going to read it all. I got to get going. I do want to point out that somewhere on here, where? There we go. Pro se law clerks. 1, 2, 3, 4, 5, 6. There's 6 of them here in the Western United States District Court for the Western District of Michigan. So I should be able to call one of them people, and here's so you'll know. The way the courts do it, see, all these government agencies that have email addresses, they have pretty much a standard way of doing whatever the name is of the person before the @ symbol and whatever they've decided is the ending for their entity. So every court has, an @ with whatever it is. You can find that for your court. But then you take their name, and it would be Philip _ Green @ whatever it is for the Western District of Michigan. And so that's how you get to these people's email addresses. I emailed right to the Supreme Court Justice Kagan, and it must have gone through because it didn't bounce back. So she got it. She didn't pay attention to it, but it did go through. And we got a pro se admin assistant. So you could start with Stephanie, right? Or just email directly. Those are things I could have done, and I will do, but I had other things I wanted to do first. But again, it's easy enough to find. Just look for some kind of clerk's office year in review, or make a phone call and say you need to talk to a pro se law clerk. Okay, and that's where you get your legal advice, right? And then you're going to point out the laws have been violated. You're going to say, what we're going to say, it depends on, I guess, what it is you're after. And really that isn't my thing today. My thing is just to point out a whole bunch of things that are wrong. So I did that one. I did that one. What's this here? Yes, I got to do this one. If you can again, hey, if you can donate, please do. I won't ask again this time, but stop. Hopefully I won't ever have to ask again. I'm going to show you what I'm doing now, and I'll have to have a whole nother video to explain it in detail, but I got 4 days to pay my rent, so that's why I'm kind of, pushing to get a few dollars. Enough of that. Moving on. Another good thing to download, right? All these things, everything I do, I just find online. Somebody asks, where do you get your information? It's all online. I don't have a book anywhere. Well, I do have a few. Got a few Bibles laying around here right behind me. State sovereign immunity and the False Claims Act. See, we want to use the False Claims Act, respecting the limitations created by 11th Amendment upon the federal courts. Sure. Where we will respect the law. We just want it enforced. And because I can't read all these things, it just takes too long, I have to highlight some parts, and I probably missed a whole bunch of good stuff I could have told you, but let's just go with what we got. Because states can be sued in federal court only when the plaintiff is the United States or another state, to answer the question of whether a state can be sued under the FCA, courts must first determine the identity of the plaintiff in such actions. Because most courts find that it is the United States who is the real party in interest, they conclude that states cannot invoke the sovereign immunity to dismiss these claims, even when the plaintiff prosecuting the action remains the individual whistleblower. Right? This is why you want to do Qui Tam. This is what a Qui Tam is. You want to make the United States of America the plaintiff. Now, whether we need to say the United States of America or United States, I'm not really sure yet. I'm going to have to get some legal advice on that. The United States of America is the republic created under the Articles of Confederation and Perpetual Union. In the very first article, it says the style of this confederacy shall be, parentheses, the United States of America. It's a proper name of an entity. But then we have this thing called the United States, and when you look at what they call the United States, they say, well, that's the 50 states and Washington, D.C. And so, as I look at these things more, I say, well, that would mean then that the United States of America, that union, somehow went into union with this entity called Washington, D.C., that is representing another entity called United States of America, without the. And so what you have is you have this joining, this union of the Republic, the United States of America, which we want to be in, with the democracy, United States of America, which is really under the jurisdiction of King George III's successors, because in the Treaty of Paris of 1783, it says in the very first paragraph that King George III is saying he's the king of the kingdom United States of America. Doesn't have the capitalized. It's a different name. Proper case the, or proper case, the United States of America is the Republic. United States of America is King George III's kingdom. They have us in King George III's kingdom. We want to be in the Republic. You're in King George III's kingdom as your surname, comma, given name. Anyways, continuing on. Because all that's going to mean is, well, what do I put first? Do I say it's United States as a plaintiff, or do I say it's the United States of America? I'm going with the United States of America. That's what I decided it is. Historical background. This part discusses the legal evolution of Qui Tam actions, from their inception in England to their importation into the New World and subsequent incorporation into the FCA. So the False Claims Act incorporated the common law doctrine of Qui Tam. Well, let's see what that means. The Qui Tam action first developed in England in the 13th century as a means of private parties to gain access to the king's court, because that court considered disputes involving the king only. Oh, okay. If you want to get something to the king's court, somehow it has to involve the king. Well, how would you do that? Well, you'd point out that somebody broke the king's law and you're bringing it to his attention. Lawyers considered the king's court to be superior to local courts, which usually had jurisdictions over disputes between private parties, because of the local court's poor reputation for competency and fairness. Right? That's the problem with the local courts, and that's the courts we're going to. We're not going to the king's court, we're going to a local court. it'll be the King's Court when they put a court seal on your paperwork. Otherwise, it isn't. There existed two types of common law Qui Tam proceedings. The first was brought by individuals suing for redress of their grievances. The second type was brought by individuals known as common informers who sued for part of a statutory penalty and were considered bounty hunters. You want to be a bounty hunter, you need to do Qui Tam action and make the government the plaintiff. You're the ex-rel saying, hey, them people over there are breaking the law. They didn't necessarily do it to me, but they're doing it. Right? Is there a penalty involved? I would like to get my my reward. You're just claiming the reward for pointing out that somebody is breaking the law. Eventually, the King's Court expanded its jurisdiction to include disputes between private parties, and the common law Qui Tam action fell into disuse. In addition, the overzealous pursuit of bounty by Qui Tam realtors resulted in a distrust of the common law informers. Okay, but whatever. It just fell into disuse, but they can't make it go away. Common law Qui Tam is common law Qui Tam, and we've already seen that we can tell the court to take judicial notice of the common law. Take judicial notice of this Qui Tam action upon which the United States of America is the plaintiff, and I, Robert Allen Rytlewski, am its realtor. And that these people over here have violated this law, boom, boom, boom. And I demand the officers of the United States enforce the law. In the name of the sovereign, the United States of America. All right, then be quiet and see what they say. As the common law Qui Tam action declined in importance, statutory Qui Tam actions became more prevalent. Attractiveness of Qui Tam statutes in 14th century England resulted in large part from the absence of an organized and established police force. Thus, in lieu of formal governmental authority that enforced the law, Parliament established a series of Qui Tam statutes to enforce the penal law. Well, that's what this FCA is. It's a Qui Tam that's going to enforce the penal law. Because if you break the law, well, it's a penal law. The realtor could bring suit in either a civil or criminal proceeding. The choice of proceeding determined the manner in which the court conducted the suit. The Qui Tam realtor's authority even allowed him to bring indictments against defendants, although Parliament eventually limited the realtor's criminal prosecutions to informations. Well, that's what you're doing now. You're going to give them an information. So really it comes down to, who do I need to get this Qui Tam to? Right, I understand what it is. What's the procedure? Well, that's why go ask a law clerk. What's the procedure for filing a Qui Tam action upon which the United States of America is the plaintiff and I am the relator? And they're going to say, well, what's the problem? And you're going to say, well, the problem is you won't tell me what I want to know. As what the crime is, well, that'll be on the frickin' Qui Tam proceeding. So what's the procedure? You can look at it here in just a minute. Just tell me how to do it. I'll be happy to give you a copy. Despite the utility of Qui Tam actions, Parliament took steps to rein in the power of Qui Tam realtors in order to curb abuse of realtors' power. Right? So, again, I don't have time to read this whole thing, so you just have to kind of go through it. There appears to be no evidence, however, that common law Qui Tam suits were ever filed in colonial North America. Well, I think the reason for that is that it doesn't happen publicly. It all happens privately. Right? Because you're pointing out that a law has been broken, and it's not going to be a court case as far as having the law as far as having the I want to say this. As far as having the law judged, they're going to go execute the law, and then the United States of America is going to bring the suit, and you kind of fall off the page. Right? The plaintiff is, the sovereign. But you still get your remedy. The historical record demonstrates that colonists were aware of the utility of Qui Tam suits. For example, at least 10 of the first 14 statutes enacted in the United States Congress relied on Qui Tam provisions for enforcement. Well, they just said that appeared no evidence, however, that the common law Qui Tam suits was ever filed. Yet the first 10 of the 14 statutes enacted by the Congress are built on the Qui Tam provisions for enforcement. I need to go see what those are, actually. That's number 53. That'd be tomorrow's practice. Colonies and later states enacted Qui Tam provisions to help enforce the law. Most courts at the time recognized Qui Tam provisions presented the joinder of public and private interests. Represented, didn't prevent. It represented the joinder of public and private interests. That's what it's doing. As in England, Qui Tam provisions were popular because an effective police force was non-existent, and I can tell you that to be the truth today. As can pretty much anybody who's ever done any of the things that we've tried to do, that they just don't want to enforce the law. Not the sheriff, not the local police, not the FBI, not anybody that I found so far. So Congress incorporated the underlying doctrines and principles behind such actions into the FCA, as will be discussed in Part 2. And the underlying doctrines will be the common law doctrine of Qui Tam, upon which the king's the plaintiff. And so, it's a plea of the crown. History of the False Claims Act. Congress enacted the FCA in response to rampant fraud that was perpetrated upon the United States military by government contractors during the Civil War. The act encouraged a rogue to catch a rogue. And, paid like half, 50%. And so that's why there's this thing about having 3 times damages when something happens, because you're in Qui Tam, you're up to 30% is going to come for the 3 times damages. Although a legislative history of the act focused specifically on military contractor fraud, the act was applicable to fraud committed by government contractors generally. Unlike the modern day FCA, the 1863 act required the realtor to bear the cost of pursuing his suit, but not anymore, because the United States, if they're the plaintiff, hey, they don't pay. They just prosecute. In Griswold, the court held that all the government could release a Qui Tam defendant from damages owed under the act. It could not release the defendant from damages owed to the informer. And so that's how they get you your remedy. They say either you pay him what you owe him, or you're going to pay him what you owe him, give us damages, and then go to prison. There's your choices. Take one. Well, I think they're probably going to want to pay you instead of going to prison and, paying 3 times damages to the government. And so it's like a party foul. Okay, hey, no harm, no foul. I'll give you back your property. I guess I made a mistake. Unlike the modern version of the FCA, the Informers Act lacked the provision limiting realtors to recovery on actions brought alleging fraud and was previously unknown to the government. Yeah. Instead, to make out a valid complaint, the realtor had to contribute new information previously unknown to the government. Yep. You need to tell them something they don't know, like give them a name. The statute, as amended in 1943, also allowed the DOJ to intervene and take over prosecution in an FCA case. So one of the things I had done this week, although I haven't, and I did it as a Qui Tam, and I sent it to the administrative offices, I did it against, the county, which when you get their W-9, it says County of Kent, but, they're supposed to be Kent County, and everything they do is in the name of County of Kent, but that isn't the name of the government, and none of these people are properly elected, and I could go on, and I did all these things in different videos. So that one, and I did one with Planned Parenthood for the same thing, because they've already been found to have been violating the federal law, just not prosecuted. So, there's all sorts of low-hanging fruit that you could pick on. Basically, any 501c3 corporation that doesn't have, and any entity with an EIN number that for any reason thinks they're tax exempt, has to have an acknowledgement of some sort. They're called determination letters or letter rulings from the IRS, that evidence that the IRS acknowledges and agrees that they are a tax exempt entity. So just, submitting the paperwork isn't enough. You need to get these letters from the IRS. And, they don't give them unless you ask for them, I guess. The 1986 amendments also provided greater protection of the realtor's interest in the action and permitted greater participation of the realtor in the FC action. Although the government has the power to settle the case notwithstanding the realtor's objection, the realtor has an opportunity in a hearing before a court to enjoin the government from settling. After a Qui Tam realtor files a sealed complaint in the federal court, see, this is the procedure under the False Claims Act. Step 1, after the Qui Tam realtor files a sealed complaint in the federal court, the government has 60 days to investigate the complaint. What's the first thing you got to do? You need to file a sealed complaint in the federal court. Not sealed from view. Sealed as saying the court has seen it and it's been logged in the official record. Within the period of time, the government may elect to intervene and proceed with the action. The government does not intervene. It has a primary responsibility for prosecuting. If the government does intervene, I should say, it has a primary duty for prosecuting the action and shall not be bound by any act of the realtor. Excellent, man. You guys handle it. When a realtor brings an FCA action against the state, the procedure is no different than when the defendant is a corporation or an individual. States, however, often assert a defense of sovereign immunity in order to dismiss the suit, which we talked about earlier, where they can't do that if it's the government, the United States of America, is the plaintiff. If you're trying to do it as a civil action, just as, you doing a Qui Tam, then they possibly could, because they're going to say, well, it's not the United States of America that is the plaintiff. So let's make him the plaintiff. And it also says, a defendant is a corporation or an individual. So it could be the government, it could be a corporation, or it could be an individual that you can use the False Claim Act against under the Qui Tam procedure. And then this goes into this thing about the 11th Amendment and the idea of having sovereign immunity, and all that shit goes out the window as soon as you say, well, it's the United States of America that's prosecuting. I'm just the relator. Okay, one more thing. And it starts with this idea of what in re means. Because I got, I got something that was in re sent to me. So what does it mean? In re, in the matter of, is a term with several different but related meanings. In jurisprudence, the in re is used to indicate that a judicial proceeding may not have formally designated adverse parties or is otherwise uncontested. The term is commonly used in the case of citations of probate and bankruptcy proceedings. So in re is used in probate and bankruptcy, and it's used when there are no formally designated adverse parties, and it's otherwise uncontested. So you got a bankruptcy case with no creditors. It's uncontested, but there's a bankruptcy case. Well, how would that be? Why would they do that? Well, I don't know. Maybe to steal your property. And so, real quick here. We have a thing called the United States Trustee Program in America. And it says the United States Trustee Program is a component of the Department of Justice, responsible for overseeing the administration of bankruptcy cases and private trustees under 28 U.S.C. 586 and 11 U.S.C. 101, which is basically the whole bankruptcy code. Title 11 is bankruptcy code. Title 28 is the judiciary, and 28 U.S.C. 586 is what's going to say what the trustee is responsible for. Anyways, this program consists of 21 regional U.S. trustee offices, and they always use U.S. This is, that's interesting too. Not United States, right? U.S. Nationwide, and the executive office of the U.S. trustee in Washington, D.C. This site contains information about the United States Trustee Program and the federal bankruptcy system. Welcome and thank you for visiting on the Department of Justice internet site. So if you were to Google the United States Trustee Program, you might find this written and actually on the website. Well, they have lots of things to look at, but I'm going to show you the ones I picked. So what I did, first of all, so here is the Act. Excuse me, not the Act. 28 U.S.C. 586. Each United States trustee within the region of such United States trustee is appointed shall. And here's a list of duties. And we could read them all. And I'm going to do a much better video on this, but I just want to point out a few things that I did today because I wanted to get a complaint in. It was based on this. 5. Where are you? Oh, here we go. F. Notify the appropriate United States attorney of matters which relate to the occurrence of any action which may constitute a crime under the laws of the United States and, on the request of the United States attorney, assisting the United States attorney in carrying out prosecutions based on such action. Now, this is, United States lowercase attorney, so it's not the Attorney General, and it's not the guy called the United States Attorney. That's an office. This is an office. This is who is the United States Attorney within the district. I say that's the Chief District Court Judge. That he's the United States Attorney within the district. And this trustee, U.S. trustee, is his attorney in bankruptcy matters. So, anyways, this has got a lot of good stuff, but this is getting kind of long. I'm going to stop and just get it done. Again, I put this complaint in today, and again, I've done all these by the mail so far, or I mean by email, because I can find email addresses, and well, I like it to be out there, so if anybody ever was to FOIA court a record at AOL.com with the government, they would have to give you all the email addresses, or all the emails, and what the replies were, and anything that had to do with that email as it worked its way through the system. You got to find a way to make them do it, but that's a matter of finding a way to get the laws enforced. So here again, the United States of America, ex-rel Robert Allen Rytlewski, relator, relating, bankruptcy fraud, identity theft, common law felony, N.R.E. Robert Allen Rytlewski, Social Security number 374-506794. Yes, that is my property. Both of those. It's my estate and my account. Or my accounts, or my estate's account. So the director is Clifford J. White III, and it's the Office of U.S. Trustee. Now this is a local branch here in Michigan, but I sent it via the USTP bankruptcy fraud email address, which you can find on the Department of Justice website if you go to the U.S. Magistrate or the U.S. Trustee section. And I just said on there, forward to the U.S. Trustee and Matthew W. Cheney. So Mr. Director White and Matthew W. Cheney. I just wonder if that's Cheney, if he's related to Cheney, who is the Assistant U.S. Trustee here in Grand Rapids. I, Robert Allen Rytlewski, sole owner of the estate Robert Allen Rytlewski and its Social Security account 374-506794 as relator for the United States of America, now inform the U.S. Trustee, agents and principals of ongoing bankruptcy fraud involving my lands and estate, for which I demand you immediately investigate, adjudicate, and provide a complete remedy and equity. It is my belief this crime is perpetrated against all inhabitants of the United States. You don't want to be a resident, you want to be an inhabitant. This common law felony appears to have begun at my birth as evidenced by, I got a certified copy of record of birth issued in the name Rytlewski, Robert Allen for the child, Robert Allen Rytlewski. I should open these as I do them. It would be easier because they're exhibits. So I'm talking about this document right here. Certified copy of record of birth. They got that nice. This is a nice gold court seal. See, this is what your paperwork's missing. You don't have a court seal on it. This is the Circuit Court of Bay County, Michigan. Now, see, it says Circuit Court of Bay County, but this Yahoo over here says he's the clerk of the County of Bay and the Circuit Court thereof. Well, it didn't say County of Bay. It said Court of Bay County. And this is the idea of they mix the two jurisdictions together. The court is in Bay County. This dude is in a foreign jurisdiction called the County of Bay. And so this is there's a foreign transfer going on here someplace. This is where I was taken out of one jurisdiction and put it in another. I want to be in the court. I want to be in the Circuit Court of Bay County jurisdiction, not the jurisdiction of the County of Bay and the Circuit Court thereof. But if you read these things, it says on here that the following is a copy of the record of birth of, my all caps, now remaining in my office. Stop. Why is it in his office? Why don't I have it? Where's my record? Where's my copy? Right? So, your birth records never left the county. It's still remaining in the county clerk's office. He didn't send anything to the state. But back to the complaint. So that's what we're talking about. This is what this is. Recorded remains in the office of the clerk, County of Bay, State of Michigan. Record number 2137, Lieber F. Sure enough, man. Look at, see, right here. Record number, Lieber, page, the date that it's recorded. That is my property. But they put it in the name of some dude named Rytlewski, Robert Allen. Well, that isn't my name. So, this is where the fraud began. We're going to be talking about this is the certificate of live birth. And what did I say about this thing? 2, certificate of live birth, local file number. Hey, it's got the same local file number, 2137, for the child, Robert Allen Rytlewski, right? That was the child up here. Received by local registrar John H. Gates on September 18, 1958, record of which is certified remaining in the same office as a certified copy of record of birth. Note, local registrar received said certificate after time allowed by state law. Well, what could that possibly mean? Well, that would mean if you went down here and you looked at when date received, it says September 18, 1958. I was born on September 5th. 1958. Do the math, that would be 13 days before John H. Gates, the registrar, received a copy. Well, if you read the vital statistics law, he was supposed to have seen it within 5 days because he needs to give it to the state within 5 days. And so the law was intentionally not properly complied with. And so there's an omission in the record. And now this says also that I, Stephen Toth, clerk of the County of Bay, that same foreign jurisdiction, the circuit court thereof, the same being a court of record, having a seal, do hereby certify that the following is a true copy of the above record now remaining in my office. All your birth records are in your birth county office. They never made it to the state, let alone made it to the national government. So you've never been seen in your proper person within the United States of America. Your property may be here, you're all caps, but you and your proper person aren't. Because none of this, well, first of all, none of this has your proper person name on it. At least mine doesn't. Mine's in all caps. I'm not going to make too much of a deal about that. I'm just going to say all these records never left the county. And so we got to subpoena the records wherever they are. Okay. So, Social Security account. Okay, so I got these 2 birth records, and they're remaining in the county clerk's office, basically, of the County of Bay, not Bay County, where the court is. Different jurisdictions, foreign to each other. Social Security account in the name Robert Allen Rytlewski with Social Security with number 374506794. that the stub portion of the Social Security card claims the name of the owner is Robert A., middle initial, Rytlewski, a pseudonym. Officers of the Social Security Administration stole my identity and embezzled my private property. Yeah, that's what I say they're doing. I do say that. I'm going to show you. Because I don't know if you got one of these or not, but hey, they're doing it to me, they're doing it to you. So this little piece over here is the front and back of the thing called the stub. Detach this portion from the upper part of the card and keep it in a safe place. Well, I did. Your name, a Social Security number, account appear on the other side. Well, on the other side, what appeared was the Social Security account number and the name Robert A. Rytlewski. But that isn't me. Yet my Social Security account was put in that name. Well, I think that would cloud the title. Right? And I've tried to get Social Security to change it, and they don't want to play. What are you to do? Donate. I didn't mean to go there. I'm sorry. Okay. Embezzle my private property. 4. Passport issued in the name Rytlewski, Robert Allen, evidencing the kidnapping of my person into a jurisdiction foreign to my birth. I, Robert Allen Rytlewski, and my proper person was not herein named as a citizen national of the United States, and instead have been shanghaied and now unjustly presumed lost beyond the sea. And if you look at what they do on your passport, if you were to read the... Right, so this is like the inside cover of the book. Of course, the other side is the outside cover of the book. So this is the first page of the book, and it says the Secretary of State of the United States of America hereby request all whom it may concern to permit the citizen national of the United States named herein to pass without delay or hindrance, and in case of need to give all lawful aid and protection. Well, I'm not named herein. The only place you see anything with my name that even comes close is on the inside cover, and that's backwards. Rytlewski, Robert Allen. And it says that my place of birth is Michigan, U.S.A. Right? United States of America. There's no the USA. This is King George's jurisdiction. This is the Republic. And right here where this space is, I believe, is where your name should have been printed in there. It should say Robert Allen Rytlewski, and I should have signed Robert Allen Rytlewski here, and it would have been a wonderful day. And eventually that's how it will be. Except it may not be from the United States of America for me. It may be from the Holy See. I may actually have both of them. I want both. This document evidences so these documents evidence the ongoing conspiracy that presumably murders a man's proper person, then steals his identity, clouds the legal title and equitable titles of his private property, allowing the conspirators to administer his estate and extort its wealth by use of bankruptcy fraud. I have included copies of these documents as exhibits with this complaint. And so there you go, right? You got Rytlewski, Robert Allen Rytlewski, Robert A. Rytlewski, but nowhere have you seen my proper name. Take judicial notice. I'm back from the dead, sovereign of a nation of one, citizen of the kingdom of heaven. My attempts to establish my domicile and register my natural and legal persons in an elemental republic of the United States of America, right? That's the proper style, land of my birth, have been denied by de facto agents obstructing justice within the township, county, state, nation. I have not received proper notice in my own name of any proceeding under Title 11 of the United States Code or any other law involving my property or myself in proper person, Robert Allen Rytlewski. If it don't come in that name, in proper case, you ain't talking about me. If it looks like that and it's uppercase, well, that's my property. That's my legal person. That's my natural person. Right? I'm neither of those. I'm the immortal living soul, created in the image of God. Here is one of his people, and he gave me an animal. That animal's name is Robert Allen Rytlewski. And he gave me property, and that property is in the name Robert Allen Rytlewski. If it's got that name on it, it's my property. Further on, take judicial notice, right? Robert A. Rytlewski, is not me. It's a pseudonym created by others to conceal their crimes against humanity. Rytlewski Robert Allen is not me, for I am no man's property. Within the last year, I have attempted to expose various ongoing violations of the laws of the United States to officers of the United States, including submitting a complaint to the grand jury of the U.S. District Court, executed August 21st, 2015, received by the court August 20th, which I did do. And that would be this one? Yes. So here last summer, I wanted to put a bill of information into the grand jury, and I found, hey, the jury's got an email address. I'll send it to them. And so I wrote this thing up, and it's against Planned Parenthood Federation of America, saying they've violated 2 U.S.C. 441, 26 U.S.C. 7201, 18 U.S.C. 1001. And, right, so that was my complaint. It was one page. And I've done other videos on this, but I'll put all the wording here if you want to stop and read it for a second. Go ahead. I'm not going to talk about it, but I'm going to continue on. But the idea with that was, okay, this generated, okay, I did it August 21st and was received by the court. That was the interesting thing. So that's the date I did it. And I did it by email. So, I mean, it went to the office on the 11th. But it was received, so this would be 8 days later. It has to have something to do with the timing. All this shit has to do with timing. August 20th, right, by the clerk, Tracy Cords, who's not there anymore, as it turns out. I wonder what may have happened. Okay, so Tracy Cords got it. This generated a court order dated August 21st, issued by an individual identifying himself as Ray Kent, U.S. Magistrate Judge, representing the United States District Court, Western District of Michigan, Southern Division, obstructing justice. Ray Kent issued this simulated legal process in R.E. Robert Allen Rytlewski. Yes, he did. NRE, Robert Allen Rytlewski. That means that's a court case. United States District Court, West District of Michigan, Southern District, NRE, Robert Allen Rytlewski. That is not how I sent it. Right? I didn't send it in my uppercase name, but he certainly put it in that name. Order rejecting pleading. The court has examined the following documents received August 20, 2015, and orders the clerk to reject the criminal complaint and return the documents to, hey, me and my proper case name, for the reasons noted below. Robert Allen Rytlewski is attempting to file a criminal complaint. Absolutely. A criminal complaint may be initiated only by a United States Attorney's Office and not by an individual. It is so ordered. Well, I happen to disagree with that, because that isn't what it says, but that's what he said. Ray Kent, U.S. Magistrate Judge. Thank you, Ray. Right? What Ray showed me is, hey, there's an open court case someplace with my all capital letter name on it. There it is. It's an order in a court case in re Robert Allen Rytlewski. Well, what could that possibly mean? Well, let's see. Bankruptcy and probate courts use the style of hearing in the matter of R.E., and it is the district courts of the United States that have exclusive original jurisdiction in bankruptcy. I can only assume there is an ongoing involuntary bankruptcy case involving my private property, Robert Allen Rytlewski. Right? It's not me, it's my property, for which I and proper person have not received proper notice. Now, they opened up a case. Somebody is administering your account. They're signing shit for you. Or, they get power of attorney to sign stuff for you, and they end up in bankruptcy court taking property out of your account. Subsequently, I filed a complaint with the United States Court of Appeals, 6th Circuit, that Ray Kent is unconstitutionally appointed and his denial and obstruction of justice. Standard Form 61, appointment of affidavit, bifurcates the oath of office mandated in Title V, U.S.C. 3331. Hey, that's where we started. Invalidating any appointment depending on documents as evidence of administration of the proper oath of office. And as we read in the handbook, he's got to take 2 oaths. One of them is this one. 5 U.S.C. 3331. So that would have been, where are we now? Where are we now? We're almost done. You're still here. Thanks for hanging on. Okay, so I filed a complaint with the Office of the Circuit Court Executive, United States Court of Appeals for the 6th Circuit, because that's where it says to go to if you got a complaint for judicial disability or judicial misconduct. And my last video was really based on this. But at the end of the day, hey, they did open up a court case, and I got a court case number. And they're trying to say that this will acknowledge receipt of your complaint of judicial misconduct against the United States Judge Ray Kent. Well, I specifically said, hey, he's not. There is no judge named Ray Kent because there's no attorney named Ray Kent. And he couldn't be a judge. He couldn't be a magistrate judge unless he's an attorney. And there's no name Ray Kent on the Michigan Bar Association website. Yeah, that was what that was all about. But okay, but mainly I was interested. Hey, they made it in Robert Allen Rytlewski, and I'm going to say this is bankruptcy fraud. And here's some evidence. So now let's go on. Let's see where we're at. So subsequently, I filed a complaint with the United States Court of Appeals, 6th Circuit, that Ray Kent is unconstitutionally appointed and his denial and obstruction of justice. Standard Form 61, appointment of affidavit, bifurcates the oath of office mandated in Title V, U.S.C. 3331, and validating any appointment depending on this document as evidence of administration of the proper oath of office. He has a disability. He's not a judge. There's nothing he's ever done as a magistrate judge that's been done properly. So whoever he's put in jail, whose ever property they've taken, whatever the situation, it was a unlawful bankruptcy. Right? They're opening up a bankruptcy hearing, so this would be, I don't know if they're doing it as a Title VII. I guess it could be, but somebody's pretending to be you, having a bankruptcy hearing, and taking your property. So, anyways, because you can, I demand an audit of my estate and claim an equitable remedy for breach of performance by officers of the United States to protect my unalienable rights. I appoint you, my trustee, to see my remedy and demand immediate emergency relief. If you require my sworn testimony, then call and acknowledge my oath. Otherwise, accept the following declaration. I declare that I have examined this application, all accompanying statements and supporting documents, and to the best of my knowledge and belief, they are true, correct, complete. Executed April 26, 2016. By yours truly. And that was 4. What was 5? Oh, and then I sent him the evidence of my of my birth, right? Of my rebirth. So here's your baptismal certificate. These have the same problem. All these certificates I'm going to show you that would be called sacramental certificates are kept in the basement of your church, and they haven't been sent to, for me, they need to go to Rome. I'm a Roman Catholic. If they would, right, I would have my Holy See passport. I'm not seen as a member of the church because this piece of paper never made it out of the basement of the frickin', what do they call it? The worship center or something like that. Okay. And so, if you're a Catholic and you go get one of these, right, and you've had all the basic sacraments, well, this shows that you were baptized, and the notations are on the back, and it shows that you're confirmed, but they didn't put communion on there. And if you read canon law, you need to have confirmation, communion, baptism combined to be considered a full member in, what do they call it? A communicant in good standing with the church or something like that. I don't remember the exact wording. That could be how they said it in the Anglican one. But hey, if you ask them for it, they do have one. And so here's my certificate of First Eucharist. So I had all three of them that they required. And certificate of confirmation in my saint's name, Robert Allen Michael Rytlewski. Thank you. On September 5th, 1958, celebrated confirmation on the 6th of November, 1867, at St. Joseph Worship Site, according to the rite of the Roman Catholic Church, by Bishop James Hickey. Okay then. That's all you needed to see, Pope Francis. I am a member of the church, and I want my Holy See passport. Would you please issue the order? I've tried to send it to the nuncio and to the Vatican and to my diocese and to the United States Conference of Catholic Bishops and the Basilica and the National Shrine and I'm beginning to think that there's some Satanists in the church. Well, I know there are, right? So it's one of my reasons for getting in there is I want to go and pull the plank out of the church's eye. So as you can see, if you can see, that I guess that's pretty much it there. That and that's the exhibit list. So that basically that was my complaint, 3 pages. I'm saying it's bankruptcy fraud. So one way to do this, if you didn't, because most people, I don't have a court case that has XREL, my name on it. What am I going to do? Well, you can ask the court to do a search on your name. You got to pay for it. I think it's like $35 or something, right? So have them do a search on your name and say, I want you to search on the all capital letters version and the lowercase version, and do it in the bankruptcy court. Right? So, again, that's one way, or really, having looked at this, no. How about a bunch of us, please, go ask some questions to these people called law clerks, put them under their oath, make them acknowledge that you've put them under their oath, and have them tell you the procedure to check to see if there may be bankruptcy fraud going on with your legal person name and its account. Because, hey, I watched this dude's video and he said that's what's going on. And he showed some pretty convincing evidence, so I want to know. So how do I find out? And I don't want to, and when they start saying something that doesn't sound like what you want to hear, you just say, well, I need to see that in writing. You need to show me the law that says that, otherwise you're just sharing your opinion, and, well, that could be construed as an ethics violation. So, all right, all that to say, back to the beginning, right, that this SF-61 form that folks are using, who now say that they're an officer of the United States, based on this document right here, you have been appointed unconstitutionally. I've made you aware of it. Whatever you need to do to correct this, you need to correct it. I can show you down here. It says that you can. Note, if the appointee objects to the form of the oath on religious grounds, certain modifications may be permitted pursuant to the Religious Freedom Restoration Act. Please contact your agency's legal counsel for advice. Cross out the word A, oath of office. Right? You can change the form. However, the president can just issue a proclamation and change the form and say, now they're all changed, and if you want it back the old way, you need to go in and, well, you can't. You have to leave, right? We made a mistake. You've all been improperly appointed. We're going to change the record. You're now constitutionally appointed, and, oh, by the way, here's your mandates. And hand them down a bunch of stuff to do. because we need officers of the United States are the only ones who can enforce the laws of the United States, and therefore we need to make sure that they're validly appointed constitutionally, so then they have the rightful power that goes with the office. Otherwise, they're just a de facto agent, and they're just acting the part, and they don't have any power. They really can't give you a remedy, and all they can do is be a counter troll and obstruct justice. And I had enough of that. Okay, just one last time, if you can, stop now, because I am, and send me a little donation. I'm working real hard for you. Appreciate it. See ya.